Okay, finally live. Boy, I had some technical difficulties. Good to be here. It's a few minutes late, but boy, I tried to go live, and it wouldn't let me. Finally did. So let's just jump right in. What really happens when you die without a will? Why is this topic important? Because looked up some. We'll get straight here. I'm hearing some background audio. Hold tight. Let's see. Okay. So read some stats as I was just doing a little bit of prep for this video, and it said that the stat was 68% of Americans do not have a will. Yeah, maybe if you're out there watching or either live or recording, you can throw in the comments section, I have a will, I don't have a will. Maybe you have some commentary on it. Maybe I have a will and a trust. But I have a suspicion that the statistics on this YouTube video are probably not representative of what happens in America, where 68% of Americans do not have a will. But nonetheless, let's jump in. All right. Before we get into, I know the topic was what happens when you die without a will, and I'm going to hit all of that in a minute. But before we get into that, let me also address what happens if you don't have a power of attorney. And the reason I'm addressing that in this video is because typically when someone gets their will prepared, as part of the package of getting their will prepared, they also do a financial power of attorney, certain healthcare documents. So since this video addresses what happens when you don't have a will, I'll get to that in a second, probably ought to at least just mentions what happens if you don't have a power of attorney. Maybe nothing bad will happen. You'll live your life. You don't have a power of attorney. You pass away when you're 90 years old and it's never been an issue. Well, it's only an issue of not having I'll call it a financial power of attorney, if at some point during the rest of your lifetime, you get to a point where you are unable to transact for yourself and your signature, your capacity is necessary to enter into a transaction. Maybe you have an IRA in your name, and $50,000 needs to be withdrawn from your IRA, but because of an illness or injury or dementia or whatever reason, you don't have the capacity to enter into that transaction. Maybe you can't even physically sign your name. Then you're stuck without a power of attorney, because what's going to happen if funds need to be withdrawn from that IRA that's in your name is somebody's going to have to sue you in a court proceeding. Sometimes it's called a guardianship, conservatorship, interdiction, where someone will have to sue you. They'll have to really get a lawyer to prepare a whole lawsuit. The sheriff serves you while you're incapacitated. You don't answer the lawsuit. An attorney gets appointed for you. Big mess, lots of legal delays, lots of expense. But ultimately, what will have to happen is a judge in a court proceeding will have to both render you incapable of administering your own affairs, and a judge will have to select someone to be your legal guardian. Once all of that's done, then that guardian on your behalf can go to the financial institution and make that $50,000 withdrawal on your behalf to use those funds for you, because you weren't able to do it for yourself. So that's the consequences of not having a financial power of attorney. Also, when people don't have a will, they don't have any kind of healthcare legal documents, whether that in your state is called a healthcare power of attorney or an advanced healthcare directive. If you don't have that and you're in a surgery and doctors need to talk to people about treatment decisions, then the healthcare provider is going to be kind of stuck. They don't know who to take instruction from. But most states, in the absence of a healthcare power of attorney or advanced healthcare directive, I'll just call it, in the absence of healthcare legal documents, most states turn to those closest family members. But if there's disagreement among the family members, then there may need to be a legal guardian appointed through a court proceeding in order to be able to make those necessary medical decisions on your behalf. Problem is, medical decisions sometimes need to be made quickly, and there's nothing quick about getting appointed as a guardian for someone in a court proceeding. All right. Now let's jump into the real topic of the conversation here. What really happens when you die without a will? I mentioned earlier, 68% of Americans do not have a will. Mentioned also earlier, throw in the chat if you want to. I have a will, I don't have a will. We'll see if our audience is representative of the statistics in America. But what happens if you pass away, you never signed a will, you never signed a last will and testament, you never signed a will, and you just happen to pass away with some assets, whether you're young or old? What happens? Well, most of the answers that you're going to get to that question are going to be of the variety of, oh, well, if you die without a will, the state gets involved. Your state has laws of intestacy to determine who inherits from you in the absence of a will. That's the generic answer that you'll get, and there's not anything wrong with that answer. I'm going to look at it, though, from a different angle. Because when somebody dies without a will, really you have to look at their circumstances and go asset by asset to determine what happens to their stuff. And I say it that way, and I look at it from a different angle, because if you pass away without a will, you likely have some assets that pass outside of the probate process. Even if you had a will, those non-probate assets, often they're not governed by your will. So, for example, let me give you a couple of examples. Maybe you have an IRA, maybe you have some life insurance, maybe you have an annuity, maybe you have purchased a home and titled it joint tenants with rights of survivorship with your spouse. Maybe you have a brokerage account with a transfer on death, with beneficiaries attached that way. Maybe you have bank or credit union accounts that have POD, payable on death paperwork attached to it. So most people, even though they don't have a will, if they have a 401k or an IRA, when they opened that 401k account, when they opened that IRA account, whether it was a traditional IRA or a Roth IRA, when you open the account, you were asked, and you probably did, designate beneficiaries on the financial institution's paperwork. If you open an IRA at Schwab or Fidelity, or really any financial institution, as part of the account opening process, one of the questions is, who do you want to be your designated beneficiaries? You have the option to designate primary beneficiaries. If you're married, most people designate their spouse as their primary beneficiary. You have the opportunity to appoint contingent or secondary beneficiaries. If you're married and you have kids, oftentimes the kids are designated as the secondary or contingent beneficiaries. So sometimes people will die, they never signed a will, they have a $1 million IRA, and that's their biggest asset. So even though they didn't have a will, their IRA is going to be payable to their designated beneficiaries. If they were married and their spouse was their 100% primary beneficiary, even though they don't have a will, that IRA is going to be payable to the surviving spouse. Looked at the other way, even if they had a will and they said in their will, they said, I want my IRA to go to Fred, but on the financial institution's paperwork, they designated Mary as the 100% primary beneficiary, that IRA is going to be payable to Mary, even though the will said something different. So those beneficiary designations on IRAs, life insurance, annuities, and other types of assets where you are legally permitted to designate a beneficiary, those beneficiary designations control. All right. Now, what if you have no will, and what if you have $1 million IRA and you didn't designate beneficiaries? Doesn't happen very often, but sometimes people neglect to designate beneficiaries, or oftentimes John will designate his wife Jane as his designated beneficiary, and that's all he does. But Jane happens to die before John. So when John dies, there is no Jane. She died. She predeceased John. So now what do you do? Well, too many people kind of tell me that when an IRA owner dies and they have no beneficiaries, either the beneficiaries have died or they just didn't designate beneficiaries on the account financial institution's paperwork. Too many people tell me it just automatically goes to the estate. And that doesn't really, we're going to get to what does it mean to go to the estate, but that's not always the rule. The first thing you have to do is you have to look at that specific contract. If you had an IRA, if you had a life insurance policy and you pass away and there were no designated beneficiaries, first thing you do, hey, let's look at the contract, because some of those IRA contracts, life insurance contracts, they have provisions as to, and you signed off on it, as to what happens to those assets if there's no beneficiary. Now, some IRA contracts, some life insurance contracts may say that these funds are payable to the estate. We'll get to that in a minute. But other IRA contracts, other life insurance policies, you got to look at the terms of the contract. It may say if there's a spouse, and if there is no designated beneficiary, but there's a surviving spouse, it's payable to the spouse. If there's no designated beneficiary and no spouse, but there's children, then it's payable to the children. So that's the big thing there when someone dies without a will and they have what I'll call probate assets. Most common ones, I think, are 401ks, IRAs, and life insurance, but there are no designated beneficiaries. Then you have to look at the terms of those contracts to see who's entitled to those funds. It's a big deal, because if someone has $1 million IRA, all that determines who becomes a millionaire, within days of your passing away. All right, so that's why I'm starting to say, first, if someone dies without a will, you don't just automatically assume the state is going to determine who inherits everything that person owned. You have to look at it asset by asset. And if they owned an IRA, life insurance, annuity, 401k account, or some other account, where a brokerage account where they had TOD, transfer on death beneficiaries, bank or credit union account where they had POD, payable on death beneficiaries, then all those intestate laws that apply when someone dies without a will, they don't apply, because the beneficiary designation governs. So it is common for people to not die. Not die. It is not common for people to not die. It is common for people to pass away with no will, but with beneficiaries designated on their, what I'll call, non-probate assets. Okay, so with that being said, now let's assume there are some assets where they are what I'll call probate assets. There is no designated beneficiary because it either wasn't permitted or it just wasn't done. Common probate assets are things like real estate, brokerage accounts, bank accounts, LLCs, limited liability companies, corporations, S corporations, C corporations, privately held corporations, vehicles, boats. So now let's say John Doe died. Yeah, he had an IRA, named Mary as the beneficiary. Yeah, he had a life insurance policy, named his kids, 3 kids, as equal beneficiaries. But he had some other stuff. He had some rental property. He had a brokerage account that didn't have beneficiaries. He had some bank accounts. He had some LLCs. What happens to all that stuff because he didn't have a will? Well, now the state law governs what happens, who inherits those assets when he didn't have a will. Every state has their own what's called intestate law. That's the law that applies when somebody dies without a will, intestate law. Legal mumbo jumbo, if you pass away with a will, you're deemed to have died testate, with a last will and testament. So here someone died intestate without a will. What happens to their stuff? Well, maybe there's 2 different parts to that answer. One is there's going to be what is commonly referred to as a probate, a court and attorney involved proceeding. And that's necessary because those assets that the person owned are frozen. Nobody can get to them. Nobody can sell the properties. Nobody can get the properties put into their name. Nobody can manage the LLC or own the LLC until all of those assets go through the probate process. So what's the probate process? It's a court and attorney involved process. Usually the steps are someone perhaps will kind of volunteer and step up and say, you know what, and maybe it's a family member who has an interest in seeing that this thing gets completed. Maybe someone will step up and say, you know what, I'll be the administrator. Some states call it personal representative. I'm going to call it the administrator. I'll volunteer to be the administrator, and maybe the other heirs who are involved, they all agree that whoever's volunteering is the right person for the job, because you're going to have to get an administrator appointed by a judge. So a whole bunch of court paperwork gets prepared, usually by lawyers, and it all gets filed at the courthouse. And then a judge signs an order ordering that so-and-so is now the administrator of the estate of John Doe, who died without a will. So once the court issues, those court orders, then John Doe gets all of these court orders, and he can go to the banks, and the banks will close all of the accounts in the name of John Doe, and they'll issue probably certified funds payable to estate of John Doe, and then that administrator will have the court paperwork that he or she needs to open an estate account and pool together all of those estate funds into an estate bank account. Now that administrator can pay debts, pay expenses, pay things that need to be paid on behalf of the deceased person or on behalf of the deceased person's estate. And then there's more court filings that are all signed off by all of the heirs who are entitled to inherit under that state's intestate law. And usually if a person dies without a will and they're married and they have kids, it's usually the intestate law typically provides for, in some fashion, that spouse and children to inherit the assets. Yep, all states have a pecking order that say if someone dies without a will, it goes to these people first. But if there aren't these people, it goes to these people. And if there aren't these people, it goes to spouse, children. If there's none of that, there might be siblings or children of deceased siblings. And then at the very bottom of the list, it goes to perhaps the state. A lot of people worry that if they don't put things in place, that the state is going to inherit all of their assets. And while, yes, it is possible if you have no will, it is possible that if you have really no relatives whatsoever, because the pecking order goes through the spouse, the kids, parents, grandparents, brothers, sisters, nieces, nephews, goes through all of that. And then if you've got none of that, then the state will inherit. But I've been doing this stuff for 30 something years and never seen it go all the way to the state where the person lived, but it's at the bottom of the pecking order. Okay, so and look, keep your chat coming. I'm going to get to it, and at the end in just a few minutes, and we'll go through and answer which ones are appropriate for me to answer. Okay, so at the end of that probate proceeding from a person who died without a will, there's a judgment or a court order issued for all of those non-IRA that had beneficiary, non-life insurance that had beneficiary. That stuff was payable to beneficiaries, but then there's a court order ordering that the remaining estate assets be payable to be distributed to the appropriate intestate heirs. So if John Doe dies without a will and he had 3,000 shares of Apple stock and he wasn't married and he had 3 children, likely that the intestate law is going to provide that those 3,000 Apple shares get transferred to the 3 children. So each child would inherit 1,000 shares of Apple stock, if that's the case. All right. So as I sum up that point, when someone dies without a will, you have to go asset by asset. What did that person own when they died? Did they have an IRA? Yes, they did. Did they designate beneficiaries? Maybe yes, they did. Maybe no, they didn't. If they designated beneficiaries, then the IRA is going to be payable to the beneficiaries. If they didn't designate beneficiaries, then you look to the IRA contract and see what it says. And maybe the contract says it's payable to the person's estate, or maybe it says it's payable to the person's closest relatives, and there'll be a definition of that. If it is payable to the estate, then it falls into one of those assets where the intestate laws govern who's entitled to inherit it. And all that must go through a court proceeding where an administrator gets appointed to kind of see through the process. They obviously are bound to perform their job the right way. And at the end of that court proceeding, whoever the state law says is entitled to inherit from that person based on that person's family circumstances will inherit all of the estate assets. Okay. Now let's shift it up a little bit and say a person did have a will, because I think there's a lot of confusion there. I know there's a lot of confusion there because I hear it from people every day. Many people out there, I'm sure none of you think that, but many people out there think that as long as a person has a will, then the probate is automatically avoided. And that's not a true statement. Having a will doesn't eliminate the need for a probate. Having assets in your name, and I'm going to call having probate assets in your name, not talking about your IRA where you have beneficiaries, not talking about where your life insurance has beneficiaries, not talking about where your 401k has beneficiaries. But if you have other assets, real estate LLCs, that those are what I call the probate assets. And even if you have a will, there's going to be a probate necessary because the will has to be filed at the courthouse. A judge has to sign an order declaring it to be a valid will. A judge has to confirm or appoint the executor that's named in the will. Still, there has to be an inventory of assets prepared. Debts have to be paid. And then a judge, as part of that intestate probate, a judge signs an order at the end ordering that any remaining estate assets be distributed to the heirs that are named in the will instead of the heirs who would inherit under intestate law if the person didn't have a will. Got a couple of other kind of unusual circumstances. Sometimes in order to avoid the probate, people set up their revocable living trust. The idea, things that are already in a trust when you die, they don't have to go through the court and attorney involved probate proceeding. So dad, with his 3,000 shares of Apple stock, he'll create the John Doe revocable living trust. He'll name his 3 kids as the beneficiaries of his trust to receive the trust assets when dad dies. During dad's lifetime, once he sets up the trust, he'll transfer that Apple stock. He'll transfer the title from John Doe to John Doe as trustee of the John Doe Trust. He'll name a trustee to handle matters that will, I call it a successor trustee. John will be the trustee while he's alive, and John may designate one of his children to be the trustee when John dies. And when John dies, those trust assets don't have to go through the court process. As soon as John dies, that successor trustee can then transfer the Apple stock to the 3 beneficiaries that are listed in the trust. Again, 3,000 shares of Apple stock. Each child gets 1,000 shares. And again, that's all done outside of the probate proceeding. So a lot of people, in an attempt to avoid or eliminate their survivors from having to go through the probate, they'll create their living trust. When you create a living trust, you also create a will. That will may never be used, but it might be used. So the idea is you'll have your beneficiaries on your non-probate assets. Those probate assets will be in your trust, and you'll have a will there that's, in our legal terminology, we call it a pour over will. It's a will that may never be used, but if there's still something in your name when you die and it's frozen, then your survivors will have to use your will, and the will probably says, if I die with anything in my name, I transfer it to my trust. But there'll be a probate proceeding necessary to get that asset transferred to your trust because you neglected to put it in your trust while you were alive, or you acquired that asset after you created your trust and you neglected to title it in the name of your trust. So sometimes stuff gets missed, and we have to use the pour over will to go through the probate process to transfer that asset to the trust when somebody passes away. All right, let me jump over and see if there's some relevant chat. I have a will, but I should have a living trust. Joe T's being honest. So good afternoon from Florida, Kevin. Great to see you. By the way, I'm talking to you now live from Louisiana. Kind of our estate planning law firm leverages not only our deep knowledge of Louisiana's unique laws, but we also extend our expertise to clients across the country because we've recruited and we collaborate with our network of co-counsel attorneys in other states. So this approach allows for seamless and consistent coordination, ensuring that our clients receive well-rounded legal support tailored to their specific needs, regardless of their location. Going back to the chat. All right, does having a trust in California mean you have to pay taxes on the trust? That's a loaded question, but I like your name. I love the world, get along. So I'm going to take a stab at what you're getting at. So let's say John Doe is dad. He has a trust in California. He has his Apple stock, 3,000 shares. He has 3 kids. So if that stock produces dividends during John's lifetime, those dividends go to John. Trust doesn't pay any tax on that, but John pays income tax on those trust assets that produce income, because the living trust is what income tax rules call a grantor trust. Trust doesn't pay any income taxes. Dad, as the grantor of the trust, just reports all of the trust income on his personal return. His taxes don't change, but when he dies, the kids each get 1,000 shares of Apple stock. Generally speaking, an inheritance is free of income tax. So no, the kids won't pay income tax on that distribution of the stock that they get. Now, if they get a distribution from a traditional IRA or a traditional 401k, yeah, they'll have to pay income tax. Whoever gets those distributions will have to pay income tax. But generally speaking, if you inherit a bank account or if you inherit a piece of real estate, generally speaking, an inheritance is income tax free. But some people have assets like IRAs and annuities where whoever gets those assets is going to have an income tax consequence to there. All right, holy cow, Jay, whoever that is, just dropped $5. That's amazing. So I'm going to buy my granddaughter a gift. One of the reasons I haven't been posting much is I have a new granddaughter. She's 6 weeks old. I'm going to see her this afternoon. I see her about every other day. So I've been spending my time with little Adelaide, and she's a doll. All right, Pete, you've told me so much since 2 months ago. Thanks from Pennsylvania. Fantastic. Lucky to have an inheritance tax. Well, I wish we were all so fortunate, but we're not. A handful of states either have what's called an estate tax, which is a state by state estate tax. Might be 2%, might be 10%, might be 16%. A handful of states have their own estate tax. Some states, a handful, have an inheritance tax. An estate tax is assessed on the estate tax, where the inheritance tax is a tax assessed when you inherit. And states who have an inheritance tax, the amount of tax that you pay often varies based upon your relationship with the person who left you something. Maybe a spouse will pay inheritance tax at less than a child, and maybe a child will pay less inheritance tax at a rate less than a stranger would. So anyway, congratulations, Pennsylvania. You are, as you say, quote unquote, lucky to have an inheritance tax. Kurt said, my mother died without a will. She added my name to the deed to a property that she sold as she was married to someone when she passed. What happens to the property? So again, I just have to guess, Kurt, added my name to the deed. Well, does that mean, and I'm just guessing here because I have no idea, does that mean that your mother owned 50% of the property and you owned 50% of the property? If that was the case, you still own your 50%, and your mother's intestate heirs would inherit her 50%. She was married to someone when she passed. Is there any kind of joint tenants with rights of survivorship titling? So we really have to kind of dig in there and see the specifics. That's a good question, Kurt. Jeanette, any suggestions for POD on accounts, especially when my son and grandchildren are not responsible? I do not have a home at this time. Okay, so when I'm reading, Jeanette, that your son and grandchildren are not responsible and you're asking about suggestions for a POD account, first thing that comes to my mind, I don't know if this is appropriate, but first thing that comes to my mind is you don't want them getting a lump sum of money all at once when you pass away. That's when I read between the lines that they're not responsible. So now, if that's the case, and maybe that's not the case, but it's going to be the case for some people who watch this. If that's the case, then you need those funds to go to a trust for your son and your grandchildren. So you're leaving those monies to a trust. You name a trustee to kind of manage that money and dole it out to your son, to your grandchildren under the terms that were created when you created your trust. Now, you do say you do not have a home at this time. So I don't know if you're trying to keep things really simple and just designate people as POD, but sounds like that's not good enough for you because you'll be dumping money in their lap. And that says, what do you think about estate law being handled on the federal level? I guess, estate law being handled, it's a state issue as far as who inherits. We do have a federal estate tax that is federal, applies wherever you live. who knows what's going to happen to it, but it could go in one of about 3 different directions. It really only applies these days to really wealthy people. By wealthy, I mean people who pass away in the year 2025, and you add up the value of everything that they own, their IRAs, their investments, probate, non-probate, it doesn't matter if they own it, it's in their estate. If it's more than $13.99 million, there's about a 40% tax that applies. Married couples really get to double that because each spouse gets an estate an exemption of $13.99 million. That estate tax, who knows, could go in a variety of ways. It's scheduled. If there's no congressional and presidential action, then the estate tax exemption will be cut in half in 2026. We've been kind of anticipating that for several years, but now who knows what? There's a bill proposed in Congress to eliminate the federal estate tax, but keep the federal gift tax. So you can die under that scenario. You could die and leave as much as you want to whoever you wanted to, but you'd pay a tax if you gave away a significant amount of your assets during your lifetime. And then there's the possibility that the tax that the 13.99 million will stay in effect, and it'll just continue to get adjusted for inflation and it'll increase. And hello, that's quite the emoji you've got, which I always like to see. All right, nothing in their name but vehicles, no probation. Vehicles are unique because some people pass away and kind of the only asset titled in their name is a vehicle. So most states around the country have started to create their own vehicle procedure. And you've got to check with your Department or Office of Motor Vehicles to see if there's some streamlined approach to get a vehicle out of the name of someone who died. It's a state by state thing. You're welcome. I love the world. All right. Thank you. And my mother, Chris, says didn't need probate. There's no real estate assets below 20K. She had a car, could sell it with. Okay, there you go. So, Chris, great minds think alike. So, mother didn't need probate, no real estate. Yeah, she had a car, but could sell it with DMV. So yeah, you're in Minnesota, and you were able to sell the car through your state's special motor vehicle rules, and all you need was a death certificate. Fantastic. All right, gentlemen, my grandma wants to update her will. By the way, your question certainly gets special treatment. Grandma's update, but shows dementia. Her wishes are lucid, but afraid lawyers won't deal with her because of, yeah, that's a tough one. So again, there's a lot there, John. So I'm wondering, is this the kind of family circumstance where if she does update her will and her capacity is questionable, are there kind of family members who are going to come out of the woodwork because perhaps they might be excluded from grandma's will and they would want to declare grandma's will invalid because of her lack of capacity? So if that's the case, let's just assume that's the case, then you got to be really careful. And probably the best thing to do is maybe take her to a doctor right at the kind of same time that you're dealing with a lawyer, and get that doctor or doctors to provide you with statements of grandma's mental capacity. Because if she does a will, it's not necessarily the lawyer or the notary and the witnesses who are the ultimate determination of capacity. It might be a judge after she dies. Yes, the judge is going to want to hear from the lawyer or the witnesses or the notary who was right there in the room when she signed her will, and with those people who talked to grandma as her will was being prepared. But a judge is also really going to want to see what the doctors were saying at the time that she wrote her will. So the more, medical evidence that you could produce showing that mom had capacity to, understand what she was doing, understand the nature and consequences of what she was doing, the more likely, you're going to be successful. If she just doesn't have the capacity and she has dementia, then you just have to give it up. And may have to let the old will apply because she's looking to update her will. So it's always a tough circumstance. This is why you need to take care of this stuff, while your mind is good. And I realize circumstances change, John, and she wants to update, but she's showing signs of dementia. But there's a lot of gray area there that you may have to work with. Okay, thanks for the question, John. Yep, thanks. I love the whole world for my granddaughter. Create a living trust roughly. You can go to our website. I have a firm called Rabelais Martinez, RM Estate Law. I think the website is in the description of this video. We give people a range because everybody's circumstance is different. Yeah, so this live stream will be posted on my channel, so anybody can watch later. No problem. All right. Great, Ann, and thank you. You're welcome, Joe. All right, so we're going to wrap it up here. I'm back in the live stream mood. I've got 2-a-day planned for the next few days. Looking forward to sharing a lot of information. Got a lot of stuff coming up that I'm looking forward to sharing with you guys. So you'll have a great day. See you next time.